Today we will start with this topic, okay, the introductory topic of interpretation of statutes. Legislation we will take up in subsequent class. I'll let you know when we do, maybe in the next class, okay. So, I said interpretation of statutes, but you might have already heard about, what do you call it? The word construction as well, okay. Now, and you will see that quite often uh, they are interchangeably used. Okay. So, do they mean different things? Okay, or do they mean the same thing, or is it So, are we just using different words when we actually mean the same thing? Okay. So we will look into that. Okay, and of statutes. So we are dealing with statutes. Okay, so these are basically enactments of the legislative body. Okay, so that's what we are broadly referring to. So we interpret them, and when we say we interpret them, what do? We find meanings in the statutes. I mean, what do the statute convey? Okay, the statute convey something. Okay, they convey some meaning. So when we do interpretation of statutes, we try to find meaning of the statutes. Okay, what's written there in the statutes. Then why do we have the other word known as construction? Well, some say, whereas others disagree, okay, that, well, when we do interpretation of statutes, we find the meaning from the words themselves, okay. So you look at the words, and it is assumed that words convey clear meaning, okay. They convey crystal clear meaning, okay. There is no ambiguity, okay. It is assumed that legislators, when they legislate, they were reasonable enough to use the right words to convey the meaning that they intended to convey, okay. And then, so if they have done it so, then we are to draw the meaning, we are to find the meaning from what has been expressed, okay. We are not to look beyond what is expressed, and what is expressed is the literal edges, okay. So if you're drawing the meaning of the statute from the literal edges, then you are doing what we know as interpretation of statutes. So judges find the meaning of the law, by doing interpretation of statutes. Then, when do we need construction? Then, as you would probably have guessed already, that when the plain meaning is not enough, okay, when there is some ambiguity there, and you do not you cannot find the meaning, okay, true meaning, merely by looking at the words, or maybe the words are ambiguous, okay. In such case, you also look beyond the text. You look at the letter, you look at the spirit as well, okay. You look at the purpose. And when you find meaning that way, then it is said that, well, you are not merely interpreting, but you are construing, I would say, okay, meaning here. Now, what does it mean to say that you are you're doing construction of a statute? What does that mean? Are the judges creating the law, or are judges merely saying that, well, this is what the law is? Our assumption would be that judges are saying that, well, this is what the legislators intended, but they do not do that merely based on the literal edges, but looking also at the spirit, the purpose, etc., etc. So yeah, that's the basic difference as we understand, okay. It's not of much use later on, as we will be using these two words interchangeably, but that's how it is understood. Whereas there are many others who say that, well, this difference is of only academic concern and nothing else. So we have two different jurists who take different point on this, as I just told you. One is Salmond, who says is the process by which the courts seek to ascertain the meaning of the legislature through the medium of authoritative forms in which it is expressed. So he's referring to interpretation here, okay. So what is it? It's the process by which the courts seek to ascertain the meaning of the legislature. Words convey meaning, so you have to use a process to find what the meaning is. So that's what it is, okay. Through the medium of authoritative forms in which it is expressed. So what is authoritative form? The way it has been expressed, the literal edges, okay. So that's what he says, Salmond says, interpretation is. For him, there is no such thing. I mean, construction is no different. It's the same thing. On the other hand, you have Cooley, okay, who says interpretation differs from construction in that the former is the art of finding out the true sense of any form of words. Okay, so you understand this is based on religious rule. That is the sense which their author intended to convey. Okay, so if they have conveyed in this sense, okay, then I am to draw meaning in that sense. Okay, that's the idea. And of enabling others to derive from them the same idea which the author intended to convey. Construction, then, on the other hand, is the drawing of conclusions respecting subjects that lie beyond the direct expression of the text from the elements known from and given in that text. Conclusions which are in spirit, though not within the letter of the law. So as you can see here, says that in spirit, though not within the letter of the law. So he's saying that judges construe when the letters are not sufficient. In that case, you have to look at the entirety of the statute. Okay, so maybe you look at the long title, maybe you look at the preamble, okay, you look at all those, and then you ascribe a meaning to a particular word that does not convey clear meaning. So if you are doing as a judge that, then you are doing construction and not interpretation, as Cooley would say. However, as I told you, this debate should end here for us. Okay, it's just for the sake of your knowledge and maybe for the sake of your examination if I ask anything. But other than that, in the rest of the course, we will be using these two words, interpretation and construction, as if they mean the same thing. So are you guys with me till now? Am I making sense?
Yes, sir.
Yes, sir.
Okay.
Yes, sir.
Okay then. So that debate is done. So when we do interpretation of statutes, what do we do? As I told you, the laws are legislated by the legislature. Okay, so you elect your legislators. Okay, they go there, sit in the legislature, they make laws, whatever is the process, okay, as laid down for enactment of a particular legislation. They, whatever the rules which are there, they follow, they legislate. Okay, you may have many different, hundreds of legislators out there. Okay, and when the law is enacted, following the procedure, whatever the procedure, once the law has been enacted, where do you find the law? In the enacted piece of legislation. Okay, so from that enacted piece of legislation, from that combination of words, you have to draw the meaning, you have to find the meaning. Okay, now the thing is, the problem with finding meaning is that they use words, and words do not convey clear meaning quite often. As you know that in our radical jurisprudence, okay, especially in postmodernism, if I taught you, I don't remember, we discussed about this problem, that words do not convey clear meaning. Okay, especially if you remember, the rule skeptics would say I don't have to go into radical jurisprudence. Okay, in legal realism, the rule skeptics would say exactly that. Okay, that rules at the end of the day are laid down through words. Okay, and judges will find way to give meaning to those words, because words allow themselves to give meaning to, and judges do use that in the way they want. Okay, so that's an extreme criticism, but even if you do not subscribe to that, the idea which is also accepted by many is that words do not convey clear meaning. What is so dog about the word dog? Okay, it's by association of those three letters in that order with that creature, okay, that you think that, well, the dog word means that creature. Okay, so that's and I hope you're trying to understand what I'm trying to say. It's simply this, that legislations are enacted. So whatever is the language used, we will be dealing predominantly with English. Okay, so the problem with this language as well. The same word can convey many different meaning, and even in normal times, when you wouldn't disagree about what meaning they convey, when it is put in certain context, it might have a completely different changed meanings. Okay, so that's the problem. If words were to convey crystal clear, unproblematic, I mean, an ambiguous meaning, then you wouldn't probably have this subject in the first place. But because they don't, you have this subject. But the idea is that when judges find the meaning of the law, they have to first find the semantic meaning. Okay, they have to look at the literal edges. Okay, because that's the intention of the legislature. The intention of the legislature has been, or legislative intent has been conveyed through that particular combination of words, through that those words which you find in the legislature. So you have to find the meaning from that. You cannot go back and ask the individual legislators that what did you really mean, nor can you go back to the entire legislature and then say that, well, clarify the meaning for us. That's not the practice that we have here in India. Although you know that in France they tried that, but it didn't work even in France, I mean, after the revolution. So yeah, so judges have only one way to find meaning. It's from the words of the legislature. Now, the problem is that sometimes the words do not convey clear meaning. So in that situation, they look at the purpose for enacting the legislation. Now, here's the thing. The idea is that judges should not jump to purpose first. Judges should find the meaning of the words, okay, meaning of the legislation from the words, okay, as are there, okay. If they are problematic, okay, if they are not, if they are ambiguous, if they are not unambiguous, okay, in those situations where clear meaning cannot be derived, okay, in those rare situations, would the judges go beyond the literal edges and look at the purpose. Okay, so that's the idea. Keep in your mind, okay, all the rules, principles that we are going to discuss will have this idea, okay, will basically be about this. So judges have to first look at the letter of the law. If the letters of the law are not able to convey clear meaning in those situations, only in those situations, so you should not be overzealous about going beyond the literal edges. Okay, so you should try your best as a judge to find meaning from the letter, and if it is not possible for you to come to a conclusion about the meaning, then you look at the spirit of the law. So yes, that's essentially the idea. Okay, so you find this meaning of what is there in the statute. Statutes are nothing, as I told you. Those are basically the will of the legislature. Okay, edit or will of the legislature, and from that you find the intention of the legislature. So yes, while you find that intention of the legislature, first you have to confine yourself to the letter. Do not philosophize. Don't be a philosopher judge. Only when it is very difficult will you go into the spirit. Okay, but then there are philosopher judges as well. But not in everyday cases do they try to prove themselves to be philosophers. Okay, they don't do that generally. So in exceptional cases where they do so, but even that is discouraged. Okay, it's based on a particular idea we will look into. So yes, you essentially find out the intention of the legislature. Now, one thing I would like to add here: whether you as a judge find the intention of the legislature from the letter or of the spirit of the law, even when you find it from the spirit of the law, you as a judge still say that I am finding the intention of those who made it. Okay, of those who made it. They wanted, they intended this, and we do not give our own meaning, but we find the meaning of what had been intended by the legislature from the spirit of the law, because the letter does not convey clearly enough. So you still do not say that we are making law. But in certain situations, judges obviously make the law, and they do accept that as well. So judges basically find the true intention of the legislature. The true intention of the legislature. It is also known as sententia legis or mens legis. That is the true intention of the legislature. It is known as the meaning of the words. Okay, so intention of the legislature is essentially the meaning of the words used by the legislature, objectively determined with the guidance furnished by the accepted principles of interpretation, We are going to discuss those principles of interpretation, obviously, subsequently, so do not worry about that. So you find the meaning of the words which are used by the legislature, okay, in a very objective manner, okay. You take guidance of certain principles while doing so, and those are the principles of interpretation that we are going to discuss, okay. So those principles of interpretation are not laid down anywhere. Those are not outcomes of any. Obviously we will study general clauses act a little bit, okay, that's important for us. We will go into that, but generally the principles are not laid down anywhere, okay. These are accepted way. At the end of the day, everything, okay, everything is based on certain principles, okay. So these are the principles on which, you know, this idea of interpretation of statutes based on. So we are going to study that. So yes, so we use these principles to find the true intention of the legislature. But as we discussed a little while ago, the problem with doing that is that words, you know, they're fine, but quite often they convey multiple meanings, okay. And that's where the problem arises. But then we have certain principles that will help us out in those situations as well, which is based on the broad principle that we just discussed, okay. So some of the challenges to interpreting statutes are obviously, the first one would be meaning of the words. As I told you, that words do not convey clear meaning, okay. They can convey many different meanings, okay. So that's a challenge that we have to, as a judge, if I were sitting as a judge and if I were to find the meaning of the statute, that's the challenge that I will encounter. That is the meaning of the words, okay. Another problem, okay, one would face, okay, not as a judge, okay, but as a legislator. So if you were legislating a law, okay, you are legislating the law, quite often you legislate to address future issues, future problems, okay, future happenings, okay. You're addressing something that's going to happen in the future. But retrospective legislations are discouraged, as we are going to discuss later on. But the problem with making laws for the future is that we cannot foresee future. No matter how smart, how intelligent you are, it's just not possible for us to foresee the future. So that's a problem that the legislators would come across. They have to legislate, okay, in such a way that the future problems that arise have to be addressed now through the combination of those words right here, right now, okay. It's not possible for us to foresee what future problems that might arise, but we have to use the best of our skills, okay, best of our minds together to enact the legislation in such a way that it can address those future problems. But still, we fall short, okay. So that's another problem that we come across when it comes to statutes, dealing with statutes. So yes, we cannot foresee future circumstances, future situations. So that's something that we another problem that we come across. And another problem that you would come across as a judge is that legislators, okay, you'd expect them to exercise their best judgment, okay, while legislating, okay, but quite often it's not done properly. So you might come across contradictory provisions, contradictory rules in a particular legislation. So in those situations, what would you do? Which meaning is to which one should prevail, okay, which meaning is to be adopted? So in those situations, so if you come across these challenges, that is meaning of the words, that legislations do not foresee the future and new problems arise, what we are to do in those situations, and what happens if you have contradictory rules, in those situations you will basically use these principles of interpretation that we are going to deal with. But keep this in mind nonetheless, that the function of the court is to expound the law and not to legislate. So even when judges, okay, address these problems, they come across this difficulty of ambiguous words, or that new situation has arisen in which the law literally are not able to address, or that you've come across contradictory rules. Okay, in those situations, you as a judge, okay, um, the court has to address those problems. So even in those situations, the court merely expounds. Okay, expounds. It does not legislate. Now you might ask this question: why not? Okay, why not? Why can't the courts legislate? We'll discuss that, and we already have discussed that earlier. So that's a jurisprudential debate that we already had, but I will just introduce that. So it is said that what the court does, okay, what judges do is just dicere and not just dare. So it's essentially the same idea. They decide the matter, okay? They decide the matter by expounding the law. They do not challenge the legislators, okay? They do not create the laws, okay? They merely apply the laws, okay? So that's the jurisprudential discussion that we had, okay? Do judges make law, or do they create the law? So the idea is that judges merely do judges create the law, or do judges apply the law? The idea is that they apply the law. They ought not to create the law. So yes, so however, if the problem arises, what will the judges do? There are certain things that the judges can do. As I told you, they apply the principles, they use the principles of interpretation that we are going to deal with, okay? But what they cannot do is they cannot refer the matter back to the legislators, okay? So once the legislature enacts a particular piece of legislation, their role is functus officio now, okay? Keep these words in mind, okay? Once the law has been enacted, so for example, the law has been enacted and the president has signed and it becomes effective, okay, it's a law. Once it has happened, now the role of the legislators functus officio, okay? What does that mean? Once the law has become law, the legislature has nothing to do with it now, with the law that has been enacted. When I say that, I do not mean that subsequently they cannot amend the law. Yes, obviously they can amend the law, they can make modifications to the law, okay, they can do that. But once they do that, then again their role becomes functus officio. So what does that mean? It means that once the law has been enacted, if the judges come across any problem, they have to deal with it using the principles of legislation, which are accepted ways of interpreting the legislation, okay? That's what they have to do. They cannot go back to the legislators and then say that, well, please explain the meaning to us, or tell us what did you mean when you use the word buildings here, when you use the word industry here, or when you use the word vegetables here, okay? So you cannot do that because the legislator's position is now functus officio. So yeah, that's the problem for the judges. You cannot go back to the legislators because legislators do not have the authority now to say that, well, this is what it means. Even though these are the legislators who enacted. Once the law has been enacted, now there is a disconnect between them and what has been enacted. So the intention of the legislature here is the one which was intended at the moment of enacting the legislation. It's quite possible that a legislator, had particular idea in mind, okay, and once, she has cast her vote, she changes her mind, okay. So that will create a lot of problem for us. That, well, yeah, at that particular point of time, this is what I intended, but I no longer intend that. Okay, so that's going to be very problematic for us. And that's why we say that once the law has been enacted, the legislators, role now is functus officio. So they do not now have the authority to go and tell the judge that this is what we meant, nor will the judges come back and ask for the meaning there. But I told you that in France, after the revolution, they tried to do that, okay, because of that historical situation, but that's not what happens, okay. So judges have to refer to the principles of interpretation to find the meaning. Now, coming back to a little bit of jurisprudential, debate, okay, it's important for us. So you remember the debate on core versus penumbra, okay? Who was the debate between? On the question of core and penumbra? Do you guys remember? Are you guys there?
Yes, sir.
Okay, who Who was the debate between core versus penumbra in jurisprudence?
Hart and Fuller.
Hart-Fuller debate. Oh, well, very nice. So you remember. So it's very important for us. And Dworkin is also important for us in this context, okay? Because you remember Dworkin's chain novel idea, okay? That's essentially what is being talked about here, okay? That's the same idea which is being talked about here. So yeah, that debate becomes very important. That there are so you remember the criticism by legal realists was that the rule skeptics essentially said that, well, rules convey nothing. Okay, they don't convey anything. The judges, they already make up their mind, and accordingly they give meaning to the rules. Okay, I'm just exaggerating it so that I make sense here. We cannot go back to the jurisprudential debate again. To address this particular criticism of rules, which was developed by legal realists, Hart came up with his idea that no, some words convey crystal clear meaning, whereas there are others which do not. Okay, so in core cases where the meanings like convey without any ambiguity, judges do not create the law; they merely apply the law. If you remember, that's what Hart says. Okay. Now, in those cases where words do not convey clear meaning, okay, in those cases where the existing legislation, okay, the words of the legislation do not convey meaning clear enough for the judge to apply in a particular situation, in that situation, those are the situation that he calls as penumbra situation. Okay, where the meanings are not clear. So in those situations, he says the judges can in fact legislate. Okay, so this is what the position that Hart had. I'm generalizing here. Okay, simplifying here. As opposed to this, Fuller would say that, well, Fuller's position was essentially about us not being able to make complete separation of law and morality. So you'd say that no, even in those situations, judges, this so-called core cases, even in those so-called core cases, the judges have to find meaning looking at the purpose. So Fuller says that law is a purposive activity. So judges cannot possibly draw meaning without also being conscious of the purpose with which the law is enacted. So he gives that example of vehicle in the park, if you remember, a rule that says that no vehicles in the park. So whether a skateboard can be allowed or not. Okay, and then. So in such situation, H.L. Hart would say that, well, you have to look at the purpose, because skateboard is really one of those, penumbra cases. But then Hart says that, well, no, what about a military vehicle which some veterans want to install in the park, to commemorate some victory or whatever, okay. What about that situation? That's clearly a vehicle, okay, and vehicles are not allowed in the park. So will the vehicle be allowed to be installed in the park or not? So in that situation, if you remember, Fuller said that, well, you have to now, even though it clearly comes within the meaning of the word, vehicle, now judges have to look at the purpose with which the law was enacted, okay. So you see these two different positions here, okay. So this is what we are going to find here as well. The problem is in the borderline cases, okay, where penumbra cases. So what should we do in the penumbra cases, okay? So Hart would say that judges legislate, whereas Fuller would say that, well, that's, Fuller would say that even in core cases, forget about the penumbra cases, even in core cases, judges cannot merely apply the law as it is. They have to still be conscious, whether actively or it's in the back of their mind, okay. They have to be conscious of the purpose with which the law has been enacted. But then you have another philosopher who takes a different position here with respect to penumbra cases, and that's Ronald Dworkin, if you remember. Now Dworkin's position was this, that, well, no, in penumbra cases it's not okay for H.L. Hart to say that, well, judges legislate. Why is that? because Dworkin thinks that law consists not just of rules, okay, but also principles. Now, rules you find in the statute book, but you do not find principles in the statute book, okay. Where else do you find it? Is the political morality of a particular community, okay, as he says, okay. So that's the totality of law. So now Dworkin, as opposed to Hart, would say that in Penumbra cases, the judges do not legislate, okay. So if the rules are not sufficient, okay, if the rules are problematic, okay, in such situation you also look at the principles and then come to right conclusion about what is to be decided, okay. So now what is important for us is that why is Hart insistent on this, that judges do not legislate in the Penumbra cases but they merely apply the law as it is, and then says that, well, then law consists not just of rules but also principles. Why is he insistent on this? He is insistent on this because of this, okay. This is the idea which runs throughout this discussion. It is this, that, well, judges are not policymakers, okay. Who are policymakers? Is the legislators, okay. They are the policymakers, okay. Judges are not the one. Judges are to decide based on questions of rights, whether I have a right that ought to be protected or not. That's what judges do. Hence his book Taking Right Seriously, if you remember, okay. Now apart from that, he also says that, well, judges are not our elected representatives. Even when judges are elected in some legal system, well, they still don't represent the voices of the people, okay. So yeah, so they are not our representatives, and they are not to decide based on principles, okay. They are to decide rights, okay, on what rights one has, okay. They are not to go back into looking at, they are not to do economic analysis of the law, that if I decide in this way, then what will be the economic outcome. So for example, in the cases of negligence, learned Judge Hand comes up with this economic analysis of law. So as against that, Dworkin would say that no, judges do not do that. They are to decide, in accordance with pre-existing rights, okay. So that's what judges do. Judges do not make policies, okay. Judges do not become utilitarian calculators, okay. They don't do that. They decide based on existing rights. So if the judges were to decide based on existing rights, then we cannot say that judges are legislating. So yes, judges are to decide the matter, as he says, not just based on rules, but the principles which are part of the political community that we are referring to. So yeah, apart from that, there are many other arguments that he provides. He talks about separation of power, many other things. But the point that you see here is this, that judges are not policymakers. They decide matter based on existing rights. Judges do not create rights. Judges adjudicate, decide a matter in favor of one party or the other based on existing rights, okay. So it's not their role to create rights. So that's the reason that Dworkin says that judges merely apply the law, they do not create the law. So if you remember, we also discussed about what was that case, Donog versus Stevenson, in that context, okay. He talks about the principle of neighbor there, okay. So and then Riggs versus Palmer, all those cases that we had discussed, okay. Essentially through all those illustrations, he said that judges do not create the law, they merely apply the law. And how do we substantiate the position which is held by Dworkin here? It is this, that you will see when judges in common law legal system, I'm not referring to other legal system, in common law legal system, judges, to give their decisions towards the end of the judgment, they refer to sometimes hundreds of judgments, okay, hundreds of precedents, okay. For example, in past precedent, how a particular provision of law has been given meaning to. So they refer to all that. That's the kind of extent to which they have to go to finally say that, well, this is what the law is, and based on this law, this is the outcome that we come to. So this is what they do. So even those judges have it in the back of their mind, as in when they are trained, okay, because they are trained that way to decide matters based on what the law says. They do not say that we are creating the law. Okay, they do not create the law. But there are some judges, okay, who do accept that they create the law. Okay, so those judges who are motivated by that sociological jurisprudence based approach, okay, they clearly say that, well, we are reconciling conflicting interests. There are no pre-existing cases of interest. Deciding a case always involves reconciling competing interests. And I mean, just the way Roscoe Pound would say something, okay. So that's another approach where judges say that, well, we are creating rights as we are adjudicating. So you have all these different approaches, okay, to what judges actually do. But if you look at the judgments, in most of them you will find that judges, even when maybe they're creating the law, they do not say that they are. They say that, well, we are deciding the matter based on the existing laws and deciding in favor of the party who already has the rights, and we are not creating any such rights. Okay, so yeah, if the judges have that in mind, they then decide the matter according to the intention of the legislature. Okay, so the crux of this entire discussion is that the judges are to decide a particular matter in accordance with the intention of the legislature. Sometimes you find it from the words when it is not problematic, some other times you do not, when it is very difficult. In such case, you look at the spirit, because the letter is not enough. You look at the purpose, okay, to find out what the legislator intended. Still, you do not create the law. Now, this is what's going to be in the back of our mind as we study all other principles of interpretation. So, the duty of judges, to summarize this whole discussion, is that the duty of judges is to expound and not to legislate. Okay, so in state of Haryana versus Sampuran Singh, I will share this with you. It was said that courts are finishers, refiners, and polishers of legislation. Okay, that's what they do. Whereas in other situations, there were judges who admitted that, well, no, we are also creating. So, for example, Lord Denning said, we sit here to find out the intention of Parliament and of ministers and carry it out, and we do this better by filling in the gaps and making sense of enactment than by opening it up in destructive analysis. So he's saying that, well, we just fill in the gaps, okay? We do not destroy it, we do not go against. But he's saying that, well, we do legislate, okay? We do interstitial legislation. Justice Holmes had said in Southern Pacific Company versus Jensen that judges do and must legislate, but they do so interstitially. Okay, they do not create something completely afresh, something completely new, but only where there is a minor gap here and there. Okay, that's what Justice Holmes, as you would expect, being a sociological jurist, also a realist, okay, and Benjamin Cardozo had said the judges have a right to legislate within gap, but often there are no gaps. Okay, so it's not every other day that judges legislate. I think I'm way past the time I'm allotted to, so I will end it here for now.